Thank you, everyone. Please be seated. We are here today for the submission of 4 cases. The first case is Bunce versus Hansen et al. That case is hereby submitted without oral argument. Our first oral argument today is State versus Fredericksen, and it looks like the parties are ready. Mr. Hurd, you may begin.
Thank you. May it please the court, counsel. What is terrorism in Iowa? The General Assembly enacted Iowa's terrorism statutes in 2002 in response to the September 11th attacks in New York. Now I ask, what differentiates those attacks on September 11th from terrorism versus murder? And that all comes to the definition of terrorism, which the Iowa General Assembly has defined as an act which is intended to intimidate or coerce a population or to influence the policy of a unit of government by intimidation, coercion, or to affect the conduct of a unit of government. And it is that definition which contains the specific intent required for someone to be convicted of terrorism or convicted of a threat of terrorism. The most important question before the court today in this case is whether or not someone's statements made in the privacy of their own home, which were never intended or directed to reach the intended targets of those statements, can constitute terrorism.
First of all, I take umbrage with statements. Statement is, I think I'm going to go get myself a coffee. I'm going to pull somebody's toes off or hang them by their toes or shoot them. That is more than a statement. Would you concede that that was a threat that was said?
Yes, Your Honor. Would concede that is a threat.
Thing I take umbrage to is that it was stated to somebody who was not the target. Let's back up a bit. The person who received that threat was custodian of his siblings. And so he himself, if the threat is carried out and the court system is terrorized somehow, how could he not be a part of that? He has their permission and is in a legal position with those children because of that court proceeding. So help me understand, that is not just her best friend that she's spouting off to. I've got best friends that I've said things that I would never want to hit the Des Moines Register. This was not a best friend situation.
Yes, Your Honor. The threats were made out of Fredericksen's own admission, out of frustration, out of anger. The statements made to her son, she never intended them to reach the juvenile court judge or DHS. She found out that those statements reached the juvenile court and DHS after she received a phone call from a deputy from the Guthrie County Sheriff's Department. She did not, because those statements were not intended to reach those targets, Fredericksen, it cannot be said that Fredericksen had the intent to change the conduct or policy of
required for this offense? That's my question. Okay, it seems to me you have to have a threat to commit terrorism, so that's the intent. There's no specific intent listed there, it just has to be a threat. And then it has to create a reasonable expectation or fear of the imminent commission of the act, and that just focuses on kind of the overall circumstances. Do the circumstances lead to a reasonable expectation? I don't see with either of those things there's a specific intent. Now, terrorism itself has a specific intent, but that's not what we're talking about here. We're talking about threat of terrorism, right?
Your Honor. The definition of terrorism applies equally to 708A.5 as it does to 708A.2, the terrorism statute. And that is from the unnumbered paragraph in 708A.1, which says that as used in this chapter, these following definitions apply. So the definition of terrorism, which itself contains the specific intent to intimidate or coerce a population.
I guess I don't agree. I mean, if there's a crime of threatening to burn a crowded theater, I don't think you have to prove that I necessarily intended to burn the theater. You just have to prove that I made a threat, if the crime is the threat, right?
I respectfully disagree, Your Honor. I think that The unique definition of terrorism, which requires the intimidation or coercion of a population to influence their behavior or the conduct of government, is what separates terrorism from other criminal statutes.
Those elements, the defendant threatened to shoot judge and DHS worker in a courthouse at a hearing. What part of the elements has not been hit?
Fredericksen's intent to change the conduct.
As I didn't mean to now. I don't know if she had her fingers crossed or what, but she never said that until she was confronted by law enforcement, correct? I mean, there was no undoing of that.
The issue becomes whether or not those threats, if carried out, were done with the intent to change the policy or conduct of government or to influence a population. And I would say that in this case, they were not. They were made out of frustration and anger. She did.
Separate issues. I mean, you may contest whether or not this was a true threat, like whether she meant it or whether she was just fantasizing. But the words themselves do demonstrate an intent to affect the conduct of government. I mean, are you disagreeing that shooting a judge in a courtroom affects the conduct of government within the meaning of the statute?
It could be implied or it could be inferred that those statements, if carried out, would carry with it the intent to change the conduct of
A DHS worker to get the result that you want.
That's where the real disagreement is whether or not her threats were done with the intent to change what DHS was doing or what the juvenile court.
Worker, would you be inclined to maybe even get out of the case if she started pulling your fingers and toes off? How can that not affect a case?
It all comes down to her intent, whether it's done out of anger, whether it's done out of the intent to change the conduct.
I still think that's a separate issue, though. I think you're arguing about whether she meant it. I mean, would you agree at least the words that she said demonstrate an intent to alter the conduct of government? Whether she meant it or not is a separate question.
Say that those statements or threats she did not have the intent to change the behavior of government. It was done out of anger, frustration. So what differentiates between terrorism and murder, for example? September 11th, there was clearly the murder of thousands of citizens in New York. But what makes that terrorism is the intent of the person carrying out the act to change the policy or to influence or coerce a population or to affect the change in policy or conduct of government.
Argument that in order for us to affirm a conviction, we'd have to look into the minutes and see not only that she said, I'm going to kill this judge, but she would have also had to have said, and that's going to change the outcome in the case, or there's going to be something different that happens because of that.
Say that specific intent is seldom capable of proof through direct evidence unless you have an admission such as that. There would have to be statements in the minutes of testimony that one could reasonably infer that that was her intent to change the conduct or outcome in that juvenile court case.
Without that, we're left just with the totality of the circumstances to decide whether or not there was a reasonable inference.
Where does the timing of the statements that she made and the upcoming hearing play in? If everything was done and the kids and the court had removed the kids from her custody and terminated her parental rights, and then she said, I'm going to go get that judge, that might have, if everything was done, that seems to go more to what your argument is. But so what do you do with the fact that she said this right before a hearing?
Her statements to her son or her threats to her son were not made right before the hearing. They were made on August 3rd, 2024, with the hearing occurring on August 9th. Ms. Fredericksen was arrested on the 7th of August, 2 days prior to the hearing. So they were not done immediately before, about 6 days before.
Section 708A.5 requires someone to cause a reasonable expectation or fear of the imminent commission of the terrorism. What is that time period that is then imminent?
So this court in State v. Elaine in 2007 has restricted imminent to if the statements or threats are made more than a day prior to when the threatened acts are to be carried out, then that is not imminent. And this court came to that conclusion because if the definition of imminent was something other than that, there would be a difference between imminence for self-defense purposes.
Self-defense, wasn't Lane more about self-defense?
Lane was convicted of threat of terrorism and intimidation with a dangerous weapon, if my memory serves. The
Self-defense, I just remember, I think of this as being different because we're talking about actions in the future and not immediate. On that time frame, help me understand the record. I am not persuaded. I know that the statements were made on August 3rd, I believe, and the record does not support that there was a delay of 4 days before it was reported. What the record says in the blue brief, your brief, on page 19, you say that the son waited 4 days. But the minutes of testimony, and this was a trial on the minutes of testimony, they don't say that. That's when law enforcement contacted her. Where is the evidence of when law enforcement was contacted? Because we all know the wheels of justice don't always move immediately. But where is the evidence to show that the son did not either immediately or before the law enforcement actually reached out? Where is that?
I believe in the minutes of testimony, the son, Mr. Andrews, sends a text message to the DHS worker on the 7th, and I believe that is stated in the minutes. And then it was upon receiving that text message that the DHS worker called Mr. Andrews, and that's when Mr. Andrews relayed the statements or threats by Ms. Fredericksen. And then immediately after that conversation is when the DHS worker contacted Deputy Michelson with the Guthrie County Sheriff's Office. I don't have the page numbers right in front of me, but I do believe those are in the minutes, and that is the order and the timeline by which the threats made by Ms. Fredericksen on the 4th ultimately resulted in her being interviewed by Deputy Michelson on the 7th.
Elaine wrongly decided. Why does it make any sense to borrow the definition of imminent in a self-defense context, which means, as a practical matter, it's happening right now. It's a carjacking, it's a home invasion, not a threat of something to happen some days later.
I believe State v. Lane was decided improperly, and I think there's a logical reason to limit imminently to at least less than a day, and that also ties back to the intent required for terrorism, in that you have to have the intent to change the conduct of a population or policy of government. If the threats are not menacingly hanging over someone's head or near, it reduces or removes the likelihood that those threats will have the influence on a population or have the intent to change the conduct or policy of government. So I think those are tied together, the time frame of when the
Now, I have to kind of agree with Justice Waterman. It doesn't really make sense. Let's say you and I are just standing here, and I threaten you and say, I'm going to shoot you 6 hours from now. Does that give you self-defense to just immediately shoot me?
So, Your Honor.
And then under Lane, right?
Well, imminent under
Hours. I mean,
the time frame of when the threatened acts are supposed to occur or planned on occurring goes directly to the influence that those threats would have on a population or a unit of government.
it's just an adjective. It can mean different things in different contexts. That seems to make more sense.
Is there a difference between that word and immediately? Imminent gives more time.
And State v. Lane also stated that it does not, in order for someone to be convicted of a threat of terrorism, it does not require the reasonable expectation of an immediate act of terrorism, just an imminent one. And because they use the word imminent, I believe that that ties it to the specific intent required in that the person has to have the reasonable fear of an imminent act of terrorism, or the unit of government has to have that fear. Otherwise, their conduct may not be influenced by that threat.
Question? I mean, is that something that would be submitted to a jury if this were tried?
Sure.
Then, in this case, it's trial on the minutes, substantial evidence review. If the district court found that this was sufficiently imminent, a question that we just have to uphold if it's supported by substantial evidence?
Since this is a substantial evidence review, even though another fact finder could find that it wasn't imminent, the fact that the district court judge in this case did find it was imminent, if there's substantial evidence in the record to support it, then this court would have to give deference to that finding.
Certain change the way we think about imminent. So it seems different to say, you know, I'm going to do X, or I'm going to do X next Friday. Having that date seems to make it more imminent as I think about it, because you have some sort of fixed date in mind where you can gauge kind of the reality of the threat, I suppose.
Say that it definitely gives certainty to it, but whether or not it's imminent would still tie into whether or not it was a reasonable fear of the imminence versus it being far out in the future where it may or may not have put the fear or the reasonable expectation of fear in the person that is the intended target of the threat. And I see my time has expired. Thank you.
May it please the court, counsel. I want to start off just, I think, addressing what Chief Justice Christensen had brought up, that issue of when Mr. Andrews, the son, contacted DHS. I think the minutes make clear that we don't know exactly. It says he contacted DHS, and it doesn't say that he contacted DHS on August 7th. It says that the DHS worker responded to him on August 7th, and that the DHS worker then contacted the sheriff on August 7th, and the sheriff then contacted Ms. Fredericksen on August 7th. Just for clarification, though, the court in its ruling did say that the son contacted, I think the court says they did wait 4 days, so maybe that's where that discrepancy could come up. But I think I want to talk about a couple of things here. Obviously, Lane, I think the state's position is the court can read Lane two different ways. If you read Lane to, I think, find that really the holding was based on the fact that in Lane, the defendant was in custody. Now, the court went a little further then in saying, but even if he weren't, so he couldn't get out until at least the next day. That could still be read. I think the state's position is that the definitions that the court uses for imminence were proper. So pulling dictionary definitions, it's clear that the imminence wasn't defined within the statute, so the court looked to dictionary definitions in other cases as it does. And then I think under those definitions, you would then give that to a jury or a fact finder, and they would determine, given these specific facts, was it hanging over one's head, near at hand, threateningly near. And
On that point, in Lane, I think they pulled from Shanahan, and Shanahan pulled from Webster's dictionary, right? Black's Law Dictionary defines imminent as of a danger or calamity threatening to occur immediately, dangerously impending, or about to take place. That seems to have a tighter temporal connection than 6 days. Would you agree?
No, I think it would still depend on the actual facts of the case. I think it's reasonable for jury instructions. The court could possibly pull from Black's Law Dictionary, from Webster's. I think if you have the definitions and then you give those to the fact finder, applying those definitions is still left to the jury or the fact finder in the case to determine. I think those are arguments, obviously, a defense counsel would make. Sorry, go ahead.
What do we do about Lane? With Lane saying, the next day would have been too late. I mean, doesn't Lane at least try to put sort of an outer bound on it?
I think probably yes, that it does. And so in that instance, as we argue in our brief, if Lane is read to show that, I think the court says because it couldn't occur until the next day, it wasn't imminent, then I think we ask that specific finding in Lane should be modified because it was read something into the statute that's not there, meaning that, because it's not clear, what does that mean? In Lane, it doesn't say when he was arrested. So is it 24 hours if he was arrested in the morning and then he couldn't be out till the next day? Is it 24 hours if he was arrested that night? Is it 8 hours because he couldn't? I mean, the definition, Lane doesn't give a clear, it doesn't say 24 hours is what we mean by imminent. It just says until the next morning, possibly, so we don't know. Is that imminent? And I don't think that that's something that the court there could read in. That was left for the fact finder to determine. And so I think those definitions, whatever, I think the ones that are applied in Lane are fine. That's what they use in DeBoer. Then the Court of Appeals used those definitions. I think the problem with Lane is it goes a step further and says it restricts it to this kind of indefinite finding, at least the next day, which is not really workable for.
Meant that it needs to be tied to the self-defense definition.
I think we addressed that in our brief. I don't think that's necessary because, again, the purposes are different. The language is actually different. I think it says imminent use in self-defense. You have imminent commission. And then you step back and look at the broader purposes of the statute, what self-defense is about, an act of, that something actually is happening, so you're responding to it. Whereas here you have something that is threatened. It's not an actual act. And then again, commission could mean putting something into place. So again, with an act of terrorism, I think we use the example in our brief. If somebody were to call in a threat of terrorism on a Friday evening to a government office on a Monday, say I'm going to do this act on a Monday because the offices are closed over the weekend. Well, possibly we say, if law enforcement investigates and finds, yes, this was ready to, they had everything ready to go, they could be charged with the higher class felony of attempting to commit terrorism, but not a threat because there's a 2-day window there before the threatened act was to occur. So I don't think that this court needs to restrict the meaning based on Shanahan that it must mean the same thing for self-defense because the context of the statutes and the purposes are different.
About Counterman versus Colorado, U.S. Supreme Court case. So in order for this conviction to be constitutional, isn't there some mens rea threshold that has to be established?
Correct. The Supreme Court has said that it's a recklessness standard, and so to get it beyond just the ability to have it be a First Amendment violation, you would have to show that the person that made the threat had some sense of intent, and that intent was reckless. And so we
don't have such a finding here.
Finding here, nobody has challenged the constitutionality of the statute, but I think even looking at the facts, you do have that. Ms. Fredericksen making her statement to her son, she's had her minor children removed, given to the son by the court. He's there to pick up clothing. We're in a fraught situation where we have a future adjudication hearing, and she tells him at this next adjudication hearing, I'm going to shoot and kill the judge and the DHS worker.
We need a finding by the trial judge. I mean, it's okay for us to say, yeah, maybe if the judge found it, we would conclude that the evidence was sufficient.
Again, I think constitutional issues still have to be preserved. Nobody raised this below. There wasn't a facial challenge or a as-applied challenge. But so I think, again, the court, if it was considering, again, is it the statute itself that we would be challenging as unconstitutional? I don't think we have that here, but again, if we did, I think looking at the record, we would have enough to show that it would be harmless that it wasn't raised because you still have enough in the record to show that her conduct was reckless.
Argue that intent is not required under the statute because the statute just penalizes a threat. I tend to agree with that, but then we have the Supreme Court says, well, you have to show either intent or recklessness for it to be constitutional. Would it make sense to send the case back and let the judge make a finding?
It is a trial on the minutes here, so again, I think, I guess, finding that whether that's constitutional, I think that would be a question. I mean, under the sufficiency, I guess, thinking on the fly here, is that a fact question? I think that's a possibility the court could do, but I think even the court could, since it's a trial on the minutes here and the court's reviewing it just as the district court was, could find that.
Raised, was it? The constitutionality? Okay. It seems to me that the argument, and had the statement, the threat been made on Tuesday and said tomorrow, sounds like that wouldn't be at all nearly as concerning. There's these days between. What concerns me is there was no other hearing between the threat and the 6th or the 9th or whatever day it was, the hearing was supposed to take place, that was the first opportunity, and it was a scheduled hearing, a specific time and date. Am I correct? So are we just, I mean, I'm not saying that defendants or criminals are legally savvy, but aren't we just sending a message if we are going to follow the path of the defendant? You just need to say it and act on it really quick. Don't give a specific date. Does that really fit the statute? Is that where we're going?
That you make a good, Chief Justice, you make a good point that I don't think that would serve the purpose of the statute because, again, and I think that's where Elaine gets confusing when it says it doesn't have to be immediate, but it has to be imminent. And I think it's very, unclear for prosecutors charging that, for defendants even looking at that. What does that mean? Where do we draw that line? I think it.
Eminence. And so in Lane, even if it's not like a 24-hour period, I think the point of Lane was he was in custody. He wasn't going to be immediately released. And so it wasn't imminent. How does that jive with the fact that this was 6 days or however many days until the next hearing? How does that create imminence?
There's a distinguishing factor in Lane, two, I think, distinguishing factors in Lane that then the Court of Appeals kind of gets to in DeBoer. Lane, I think, could have been found that he was in custody, so imminence again, and there was nothing in the record that the court discussed that showed he will get out at this time. So I think it's kind of ambiguous when he will get out. And his threats, even though the court there found that the threats were still, threats, it was a little more indirect than here, where in Lane, I believe he said, when I get a court schedule, you're all going to be sorry, referencing a court shooting in Atlanta. So still kind of a qualified when, not a definitive date. Whereas here, I think you have a specific date, and it is the only feasible date. So it's not at another court hearing, I'm going to shoot. Next time I get in front of this judge, I think, again, would.
Wasn't the hearing at issue the soonest time they would all be together?
That's what we have, yes. That at the next court hearing, I'm going to shoot and kill the judge and the DHS worker, and the record says the next court hearing was scheduled for August 9th. She made those threats on August 3rd. So again, I think those go toward arguments the defense can make, at closing, that maybe this isn't enough, but I don't think as a matter of law we can say that that's not imminent.
On imminence?
Again, I don't think that we can, as a matter of law, set that. I think, again, it would still be a question on the facts for the fact finder, based on the definition, like we give juries definitions all the time. Here's what a bodily injury is. Here's what a specific, here's what a serious injury is. Now, we don't say this must be a serious injury or this can never be. Again, those could be different examples, but I think the main point being those need to be left to the fact finder, and then it would be judged on is that evidence sufficient is a different question than can it ever be imminent. So I think the facts would play on that. Obviously, if somebody makes a very ambiguous threat that's years away, I think that would strongly probably go against a finding of imminence.
I wanted to ask about the connection between the threat and the definition of terrorism and the sort of specific intention that your opponent was bringing up before, that the idea that the threat has to include an intent to intimidate a civilian population or affect conduct of government, et cetera. Do you agree with that or no?
Again, I think the statute doesn't require that specifically. It requires that the threat that's made would meet the definition. So somebody threatening to shoot and kill a judge at an adjudication hearing to affect that adjudication hearing would, if it were to be carried out, meet the definition of an act of terrorism. But at the time, all the intent that it would have to cause is that it causes a reasonable expectation of fear here in Mr. Andrews, the recipient of that threat. But it doesn't require then the state to prove she had the specific intent to carry it out. Otherwise, we'd be proving her guilty of an attempted act of terrorism.
Expectation or fear of the imminent commission of such an act of terrorism is what it says, right? And then terrorism means an act intended. So I'm just trying to connect up clearly in other words, would every shooting of a judge, well, I mean, first of all, I guess I'll let you answer my first question.
Terrorism statute is kind of wordy. It has a lot of ors. So it can mean an act intended to intimidate or to coerce a civilian population or to influence. So intended to I think, yes, again, the act is intended then would be to affect the operation of government. And so you would have somebody that's intending to, if they carried it out, that's the intent. And so I think the threat here meets the definition, but we don't have to prove that she specifically at that point intended to carry it out. It's just that that threat at that time was, Mr. Andrews believed, was a serious threat because he believed it's possible.
The nature of what she's threatening, that she had that intent to influence government.
I think that's, given all the surrounding circumstances, yes, you would look at the threat and the surrounding circumstances.
Need that. I mean, you have intent to make a threat, which is just an intent to make words, and then it has to create a reasonable expectation, which is purely in the eye of a reasonable person out there. Would a reasonable person view the act as one intended to influence government? That's why I think there's sort of a gap between the statute, what the statute requires, which is, I think, very little specific intent in countermen that it requires at least recklessness.
If I misspoke, I don't mean that it does, we have to prove the intent in the terrorism statute. I think, again, as you said better than I did, that the intent would then be what is in the definition.
You said it better than me, don't worry.
I think my time is up. So for all those reasons, we would ask this court then to affirm the conviction. Thank you.
Thank you.
Court. I want to raise the question of why the General Assembly enacted Iowa's terrorism statute. What was the harmful conduct that they were trying to prescribe or punish if committed? And within the definitions that the General Assembly put into Iowa Code Chapter 708A, I believe that the harm, it's clear that their intent was to punish people that were intending to influence a population or affect the conduct or policy of government. Without that person's having that intent, they cannot be convicted of an act of terrorism, attempted act of terrorism, or a threat of terrorism. I respectfully disagree, Justice Mansfield, that the specific intent isn't required to prove a threat of terrorism. The statute requires that a person threaten to commit terrorism or threaten to cause terrorism. I believe that language there does require a person to threaten an act which itself would meet the definition of terrorism, which includes that specific intent requirement. The
Act of government to be influenced can be, as here, who gets custody of children. It doesn't have to be some global thing that affects all of us, withdraw from the Middle East, or we're going to continue to terrorize you.
Your Honor. So the question of whether if a person threatens to shoot a judge, would that in every instance be a threat of terrorism? Because that judge has power to influence whatever that person has before that judge. If the person has no intent to change the outcome or what that judge will do, it does not meet the definition of terrorism. If they do it at...
Push back a little bit on that. I mean, let's be direct about the idea that every time somebody shoots a judge, it affects the conduct of a unit of government. Wouldn't you agree with that?
I would agree with that.
If you threaten to shoot a judge, you're threatening to do an act that's going to affect the conduct of a unit of government. You'd agree?
The question is whether or not the person has the intent to change the conduct of the unit of government. If it's done out of frustration, out of anger, with no...
To change the conduct of the unit of government. It just says to affect the conduct of the unit of government. And I thought you agreed that in this hypothetical we're using, shooting a judge would affect the conduct of a unit of government.
Agree with that, 100%.
Threat of terrorism.
Depends on whether the person who is threatening to shoot a judge has the intent on changing the conduct of government. It may be inferred that they have that intent, but if it's solely done...
But the statute doesn't say to change the conduct of government. It says to affect the conduct of government. So
if the person does not have the intent to affect the conduct of government, say it's just mental illness, they don't they think the judge is someone other than a judge. If they have done it out of frustration, just pure frustration with no rhyme or reason other than.
Things happen, somebody's mad, somebody's ticked off. I mean, frustration, that doesn't count.
There are a lot of shootings that are done out of like heat of the passion or frustration. There are also premeditated ones that are done pre-planned. But I do believe that this case all focuses on whether or not it can be inferred from the surrounding circumstances. Ms. Fredericksen had the specific intent to.
Mean, did she really mean it? I asked you this before. I'm not sure you answered it. If the words constitute a threat of terrorism, it seems like what you're really arguing is she just didn't mean it. She was frustrated. She was angry with her son. She didn't intend this to go to the police. She didn't intend this to go to the judge. She was just venting. That's really, as I understand your argument, you keep coming back to this. Did she have specific intent? And it seems like you're really just arguing about whether she meant it.
Not she meant it, it comes down to the reasonable fear that her son or the judge or the DHS worker would have. What I'm arguing is that the person, in order to commit a threat of terrorism, must make the threat with a specific intent of changing the conduct or affecting.
Because there's only two pieces. There's intent, you must make a threat. So, okay, you intended to say the words. That's just the words. And you created a reasonable expectation. It doesn't say you have to have intended to carry out the threat. That's where I part company with you, at least under the statute. Counterman's a different matter.
Correct, Your Honor, but the statute says you have to threaten to commit terrorism or to cause terrorism. And I believe that that language is what ties in that specific intent requirement of the definition.
Question about this imminence issue. So under your reading of the statute, if this defendant had said on a Monday, if this judge doesn't change the removal order by the end of this week, I'm going to come to court and shoot the judge next Monday. Is that a threat of terrorism under the statute?
Circumstance, yes, I do believe it would be because it ties explicitly the intent of the person making the threat to the desired outcome.
Is that an imminent threat?
Under Lane, no, but there is room for argument that the longer duration of time between the threat and when that threat is supposed to be carried out ties into the reasonableness of the fear of the person that is the target of the threat. So I do believe that if it's more than 1 day under Lane, it's not, it doesn't meet that temporal requirement, but there is room to allow for longer periods of time if that longer period of time does not remove their reasonable fear of the imminent commission.
Said something like, because I know how long juvenile cases can take. If she would have said something like, I tell you what, if that judge terminates my parental rights, I'm going to shoot her and pull the toes and fingers off the DHS worker. That's very different than I'm going to shoot her and pull the toes off of them at the next hearing, which is in 6 days. Isn't that a huge difference?
I agree that is a huge difference, and I believe that tying the desired outcome or change in the by the juvenile court judge is what would make that a true threat of terrorism versus just a desire to cause harm to the judge or shoot.
Actually say out loud, I anticipate this to change the trajectory of this case, you know, that if I don't get something, that it can't just be shooting a judge in and of itself is enough to change.
The case for conviction or affirming the conviction a lot easier if the threat actually contains the desired change in the unit of government, such as in State v. De Boer, where the person said, FSA, I want my land back, and if not, I'm going to blow the place up. In that case, it was an explicit threat with the explicit intent of behind that threat. In this case, a mere desire to, not mere desire, but a desire to torture a DHS worker and shoot a judge without facts or circumstances that can infer Ms. Fredericksen's intent to change that conduct of the juvenile court judge or DHS is not sufficient to sustain or affirm a conviction for a threat of terrorism. Thank you, Your Honors.
State versus Fredericksen is hereby submitted. We'll have a brief pause here while the parties prepare for the case of in the interest of LP. Looks like the parties are ready to proceed. We're now here in the matter of the in re interest of LP. Ms. Moran, or is it pronounced, am I pronouncing it correct? Moran, thank you.
May it please the court, counsel. The central issue before the court today is whether fictive kin, as defined by the legislature, may include caregivers or other individuals whose relationship with the child begins only after the department is involved and the child is removed from parental custody. The state submits that the answer to that question is no, because of the placement hierarchy that's crafted by the legislature in 2022, and that supports that conclusion, and that interpretation is consistent with the federal statutory landscape under the Family First Prevention Services Act. Relatedly, the state also sought further review of 3 issues from the Court of Appeals opinion. First, being that whether the respite caregivers here met the definition of fictive kin under either statutory interpretation based on the record before the juvenile court at that time. Second, the conclusion that intervention by that party was appropriate. And third, the state challenged the affirmation of the failure to follow the priority hierarchy for placement at disposition when there were multiple suitable relatives available to this child. The 2022 changes to Chapter 232 implemented a hierarchy of placement preference that exists throughout this chapter, and we see that in Section 78, Section 95, and Section 102. And that hierarchy is comprised of an adult relative, fictive kin, suitable other placements, licensed foster care providers, and then shelter group or residential treatment facilities.
Before that change, because when I was a DAJ, there was no such thing as fictive kin. I mean, there were those people, but we didn't call them anything. Would you agree with me that before this statute, that probably would have been considered other suitable placement? Yes. So by creating the statute, it elevated that person above other suitable.
Exactly. That's exactly what the state's position is. And that's why with the definition of fictive kin, as you know in your experience, we have these relationships that exist, and they're more family-like. So if we don't have a relative, they're more like family, so it's the least disruptive placement. And that's how it's consistent with the federal.
With the statutory definition that the legislature gave us, an adult person who is not a relative of a child, but who has an emotionally positive, significant relationship with the child or the child's family. You're saying what the legislature really meant is some adult persons who are not a relative of the child, i.e. only those adult persons who developed a relationship before DHS got involved, right?
Specifically, certainly. But I think we see that intent and that meaning looking at the whole of Chapter 232 because that placement hierarchy permeates throughout these China proceedings, and that's the intent of it. If they meant it, there's no reason for these 3 different categories to exist in these changes if you're not going to read it as a pre-existing relationship.
You say a little bit more about that because I think what you're saying assumes that maybe other categories, do they all have emotional relationships? Is that kind of what you're saying? And so they could all qualify as fictive kin?
Anyone who's providing meaningful care to a child in their care is going to develop a meaningful relationship. And that's part of the practical concerns with this case is that effectively every foster family could become fictive kin throughout a case and be entitled to intervention. And that could cause lots of delays throughout China proceedings.
Well, I mean, this is a toddler, but if it was a school-age child, could a teacher who has this child in the classroom all day, 5 days a week, spending 20 or 30 hours with the kid. It seems to me it creates a lot of problems to just say somebody who's providing care for the child post-removal gets to intervene in the case and assert some sort of interest.
That concern. I think the teacher example is an interesting one because it's the lens that's not just involvement or relationship with the child because of the removal, which is the case here, but it's a relationship with the child that just happened to begin after. So if you start kindergarten in August, but the removal was in July, it doesn't predate it, but it's independent of.
That we really don't need to decide today if it can involve somebody who had a relationship before or after the placement, that it's a matter of the level of the relationship, the type of relationship. I just don't think the timing is the most important thing as far as did it happen on the day of or the day after, but I think you have to look at the whole set of facts and just figure out, because nobody ever has just one main person in their life. Those kids in court, if you can give them 100, that'd be awesome. So I get the feeling that there's a lot of focus on the timing. I'm not so concerned about the timing as I am about the elevation of a status that's normally reserved for more significant relationships.
And I think that's where the consistency and cohesion with the federal landscape makes a lot of sense, because Families First was enacted to decrease reliance on stranger foster care and to emphasize keeping children safely at home when possible or in family-like settings. So again, it's a family-like relationship. So here, that whether that's based on the timing or not, I think to your point, the quality and the nature of the relationship is important too.
If all of the relatives and the foster care, everybody else, except for the supposed fictive kin, doesn't have a positive relationship with the child? What if these folks who were sort of thinking of as strangers, but yet through their experience, they're the only ones? Would it be okay to give them preference at that point? Yes.
Yeah, certainly, because that's where the juvenile court has the authority to select the placement category. And if you're deciding that relatives aren't in the best interest of the child, it'd be easy to say, there's not enough finding that these relatives are not in the children's best interest. But here, it was more of a comparative analysis of the two.
Respite carers don't fit under fictive kin. Are they on the priority list?
Under the third. So they're above the general licensed foster, because there's certainly yeah.
There's a pretty easy path, I should say, that these people, I'll call them the babysitters could have been considered for placement. There is a path for them, but by jumping them up to fictive kin, they bumped the line a bit. But what I have a question, a real procedural question. Where in the record, at what juncture, because everything started happening right away, did the mom walk away from the hospital and never come back? Or where was the court's finding that we are not going to do anything towards reunification?
Understanding is about 2 to 3 weeks after removal, mom was not participating in services.
Well, for the court to say the child's been abandoned, and until then, doesn't there have to be reunification efforts, even if it seems futile? My question is, I think anyone could eventually turn into fictive kin. You could have maybe even a foster parent who eventually, because maybe nobody else is stepping up. But in this case, it was a matter, were they the first person to motion to intervene almost immediately?
It was, I want to say it was 2 to 3, I think it was February and it started in November, so.
Did you have another question?
Intervention is when we need to have somebody step in to have access to, none of that stuff was happening. Wasn't DHS taking care of business? I know it wasn't as quick as usual, but this case also was incredibly quicker getting to that point because there was no genuine reunification. And normally it takes a while to get there, so those notices get sent out and nobody even notices because we're still busy trying to place with a parent. But my concern is on the intervention by jumping themselves in immediately as a party. That gives them all these bonding assessments and everything else. All of a sudden, it's kind of like if you give a mouse a cookie. You got that first step right away, which all of a sudden opens up so much more and treats them almost like the mom herself. So help me understand, how did this get to that point so fast?
My understanding is because there was no involvement from mom towards reunification. I think the parties generally looked at it as this is where this is going, and it.
Homeless, wasn't she? And she didn't come to the hearings. She didn't attend, and her attorney didn't seem to speak up and object to anything that was going on. Is that true?
Foster parents placement? I'm trying to figure out why they immediately were looking for something else. Wasn't the child safe and secure in foster, even though they were using the babysitter?
Problem was that it was a non-concurrent foster placement. I believe is part of why there was a little bit of an impetus toward figuring out where we're going to have this child go.
A few questions. If the criterion is not what, if we're not going to define fictive kin as someone who had a relationship with the family or the child before DHS involvement, then how do we define it? What's the definition?
Oral link? Is that what your question? I think then you just look at the language of the code and it's emotionally positive, significant relationship. And the state would submit here, aside from the statutory interpretation question, when that finding was made here, that the evidence didn't support that finding.
Why not?
What was in the record at that time was a couple child abuse assessments involving the mother, a prior termination order involving the mother. There was a guardian ad litem report and some drug test results, and none of that talked about the relationship between LP and the child, or LP and the respite caregivers, excuse me. Nor did, there wasn't testimony at that hearing, so there really wasn't anything factually in the record to support the finding other than the statements by their attorney and the general position of the GAL.
You talked about our deep dives into the child's life, right? Assessments, child abuse assessments, all of those things. And there was no mention of the relationship between that child and the babysitters?
Again, that relationship only came to be because of her connection to the foster family.
Okay, I mean, so you're saying they could have been fictive kin if they just waited longer? Same status, or is it, because that's what I'm wondering, because your first argument was, well, fictive kin is really talking about something that's sort of like family. That's why it's called fictive kin. They have some relationship either with the child's family or with a child that was there. And now you're saying, well, no, it can develop during the case. It just needs to develop longer.
Separate issues. The state would submit, and as it did in its application for further review, that the evidence doesn't meet the finding here. Secondarily, the supplemental briefing did a deep dive into whether or not that can exist at all. So
let me ask another question, if I could. Does the juvenile court, before it does anything, need to, with HHS's proposed placement, does it have to make a finding that HHS is acting unreasonably, irresponsibly, whatever that language is? Because the Court of Appeals said no.
I think that's a separate issue. They do need to make the.
If we send the case back, don't we need to find out?
No, because there was the juvenile court made a finding, which the state submits was not proper, that placement with the relatives was contrary to the.
Don't need to find it. So should we just leave that alone? I mean, see, that's the problem. We got that out there. We've got the juvenile court that seem to think you do need to find it. I'm interested in the state's position.
The state would submit that I think you do need that finding.
I think I've gotten a little lost in this exchange. Let me ask you this. In terms of the issues that we need to decide today, or should decide, the highest priority one seems to be the placement of the child, right? And the state's position is that it should be with family, regardless of whether the interveners were fictive kin or other suitable persons, that the best interest of the child involves going with the family. Is that right? And if that's right, and let's say we think that's the right decision under this order of priority, et cetera, do we even need to answer the other questions about fictive kin, whatnot, if we think the placement was wrong?
Technically speaking, I would say yes, simply because then you have I think the question about whether or not they're a proper party is important for how this case moves forward towards permanency regardless. And I also think that guidance would be helpful across the state.
Take you back to the question about, you had said that they would be a suitable placement if not a fictive kin. The new priority says a suitable placement identified by the child's relatives. Who are the child's relatives that get to determine who the suitable placement would be?
In this case, I would agree that the language doesn't super squarely fit with that. because we don't have a relative that's actively identifying. Mom's not doing that, so.
Of the sets of adoptive parents, probably, right?
Upon adopt, if it goes that way, yeah.
So, which takes me back to my original question of if the respite family are not considered fictive kin, are they even on the priority list at all?
The state would interpret it as they would still be suitable others. Practically speaking, that's how it would be interpreted, I think.
Actually, that kind of surprises me, that recommended by family, because suitable others seems to be a decision, a consensus that was put together by the court, the workers, everybody else. Would you agree with me that this case cannot be compared to every other case? I mean, how often do we have 3 homes that are suitable or are options for placement, and you don't have to be dealing with reunification? This is so different. And so for the DHS to have been slow in getting this or that or other, I just don't think this can be compared to anything else. This is off the grid.
Very unique case where fortunately there are 3 perfectly appropriate families. That doesn't always happen, indeed.
Do with the juvenile court's finding that placing the child with fictive kin here might actually keep the child closer to the Illinois relatives and the Iowa ones, considering that those 2 appear not to be connected anymore.
Understanding is that those families were not as in as much communication prior to LP's birth, but upon learning about LP, they reinstated contact and were having communication and visits among those siblings as well. So I would disagree with that.
Okay, we'll come back to you in a little bit. Ms. Pope.
May it please the court, counsels. People gain fictive kin throughout their lives. While children are involved in the child welfare system, they aren't equipped with pause buttons. That's the reason that we have a timeline for returning children to their homes. That's also the reason that the people that they gain, the trust, the safety that they develop in the relationships.
Help me, what was the evidence of the emotionally positive, significant relationship at the time intervention was granted, which was, I think, only a couple of months after LP was born?
No testimonial evidence. All parties agreed that the department workers would be able to provide information as it relates to the relationship. There was no question that LP resided in a foster home, was provided daycare nearly from the time that she left the hospital by my clients, these interveners.
This is what you're saying is HHS didn't contest that point.
I believe it was nearly half the time, maybe a little less than that at that point, that LP was spending.
At that time?
Just left the hospital in November and was placed in the foster home. It was then in February where my clients asked to intervene in the proceedings.
Old.
What, I guess, having 3 kids, I mean, I'm not sure how you would judge a positive relationship with it. It seems like any non-abusive relationship with a toddler would be a positive relationship. You're feeding the baby, you're taking care of the baby, babies smile when people pick them up. So that seems a pretty thin reed to say there's a positive emotional relationship with a 76-day-old baby.
I would respectfully disagree. As Ms. Helliso testified at the disposition hearing, there's a lot of growth that happens within a child's brain, their development, their sense of security, their stability, their safety, how they interact with the world.
One person?
Not. It can come by a lot of different people.
Was one of those people doing that?
A limited number. As the state indicated, unfortunately, her mother had not been participating in visits with LP.
Spade. This to me looks just like all the cases I used to see. And finally, I think the jurisprudence caught up with it and it diminished, where foster parents would almost immediately, they'd want to intervene. and they want to become an active part of the case, which actually thwarts reunification efforts, and it freaks out the parents normally. Well, we don't have that in this case because parents aren't involved. But there's a plethora of jurisprudence by the Court of Appeals on that, and that we need to focus on reunification. And so by your clients trying to attach that tag of fictive kin, it feels the very same to me, even though maybe reunification isn't the goal at this point. The next best thing, according to statute, is relatives. And I want you to address this relative talk. I'm not persuaded at all that just because there was an adoption, all of a sudden that waters down their status. These are siblings by blood. Isn't that correct? So help me understand, how are they not just trying to intervene with a statute that says you must first, in these orders, go to these categories? And I'm not finding where the court even addressed the relative stuff as far as why not relatives, because as a judge, I have to go down that pecking order. And there's relatives out there willing and able, and there's ICPC that has to be addressed. Those things take a long time. They're under the microscope because all of that other stuff went away, reunification. So help me understand, does that mean that we flush all of the efforts to acquire a family home for a child?
So I think there's a few different pieces for this child that were occurring. Relative notices were not sent out by the time that my clients asked to intervene.
But I said earlier, it's tough to get those things out timely and find people and ICPC. So I'm going to give some grace on that because this case was fast-tracked. Those things normally can happen in due time because you're working on other stuff. But this case is abnormal. Help me understand. That doesn't mean you get to say, sorry, you missed the timing, so we're going to go straight to someone else. Isn't this child down the road still going to have that desire, like most kids, to be with family?
That's possible. At the time of the intervention, there was no relationship between the child, those siblings, the child and her mother, or the mother with the children who had been adopted as well, the biological mother and those children. And so the relationships had not yet formed. Certainly it's important, the court found it was important and ordered sibling contact at a certain amount, but recognized that while all of those things are happening, children are still developing. They're still identifying who they are familiar with, who takes care of them, who do they feel safe with. And as those things are happening, we have to balance that with the time that it takes to complete an ICPC.
About the best interest finding. So if I understand the statute correctly, to not have relative placement, there needs to be a specific finding that it would not be in the best interest of the child. And it seems like the district court's findings in that respect are kind of generic, and they would apply to any case in which the child was not placed with an adult to be relative to begin with, right? That the child has a relationship with the people who are currently caring for the child. And so does there need to be something more? Otherwise, it seems like the entire purpose of this priority of placement could be circumvented very easily whenever a child is not initially placed with a relative.
We would need to look at the specific relationship, not in kind of how we look at a definition of they have a relationship. What type of relationship is it? As Ms. Helliso was able to determine in that attachment assessment, it was a very significant relationship. They were bonded, they were attached.
You also have to show, and this is where I wonder, because the Court of Appeals said no, but in order to jump, even if they're fictive kin, to jump them up above two relative placements, don't you have to show DHS acted unreasonably and irresponsibly? The Court of Appeals said, well, if the court is second guessing DHS between two relative placements, it has to show they acted unreasonably or irresponsibly. But they can bump up someone who's a lower priority without finding that DHS acted unreasonably and irresponsibly. That makes no sense.
The court gets to determine the level of care. Sometimes we have more than one, as here, we have two relatives.
Top of that list? When a judge determines the level of care, you start at the top.
They have to consider,
I think we've all conceded mom is out. Next level,
we first look to relatives, and that's what the court did. Considered the relationship that LP had with those relatives, considered their ability to provide care for her.
Before you bypass a high level of placement, and in this case, that is the parent, there is no other person. This is top one. Before you bypass that, I'll give it to you. No doubt in my mind, do they have a significant relationship with that child? And no doubt in my mind, has it grown day after day after day? And by the time they had that bonding assessment, of course, I'll give you that. But you got to go back to when this all happened. So is it right for them to gain the stronger position by the mere passage of time and having that intervention? My point is that the court never tried it on. Where did they ever have a situation where they said, you know what, we have been trying unsuccessfully to have this child, whether physically placed with relatives or even starting to have meetings or visits or whatever. Where did that happen? I just don't see it.
The relative interveners asked to intervene, and the court learned of them, ordered that there be sibling contact. Frankly, at that point, the department's position was that that LP should be placed with those relatives. However, upon learning about the relatives in Illinois, the department changed their position. Frankly, if the department would have had the authority to move LP to the relatives who intervened, the department would then move the LP again.
A to start with, then change their mind to relative B. So that tells me they are idling in the world of relatives, and the court comes in and places them with I think, a suitable other, but they categorized them as fictive kin, whatever. Regardless, DHS was working on the level of care between relative to relative. I don't understand, how did the court get to, you know what, you guys can't agree which one, so I'm going to pick one lower. How does that ever make sense?
Well, I think the court considered what it would look like from the child's perspective.
Let me ask you, I want to get back to this definition of fictive kin. I've looked at how it's kind of generally used outside of this sort of statutory definition that we're working with. And Health and Human Services talks about tribal kin, extended family and friends, or other fictive kin. Same thing, the restatement of children in the law uses the phrase in the context of fictive kin are people that are kind of like kin to the family from which the child is being removed. Or if the child's older, they might be kind of like kin to that child. They might have helped raise that child. This is very different. Why isn't this, what we're talking about, suitable other? If you use sort of how sociologists would use the term fictive kin.
If you think about where your fictive kin, the people who are important to me, who are maybe not my relatives, did I learn about them at the time of my birth, or did I develop them throughout my life? Do I have college friends who I maintain connections with, who my children play with? I didn't know them before college, but I have developed relationships with them. That happens to children too.
Fictive kin to me seems like anybody. That you are making the statute non-existent. And I'm a good example of someone. I've never been a judge in a juvenile court with the fictive kin statute in place. And the way you're treating it is as if it doesn't exist. And I can give you some good examples of what I believe fictive kin to be. I've seen it. I know it when I see it. And it never was babysitters or foster parents. I think that could have eventually turned into fictive kin, especially the life of a case when it goes for months, sometimes a couple years, and we can't find a placement, and we have burned through parents, we've burned through relatives, and all of a sudden, you know what? That foster parent has become fictive kin. But your clients jumped in at the very, very beginning before anything else could happen. How are you not making this statute just disappear if everybody, because I think everybody could qualify as fictive kin, except like Justice McDonald said, unless they're abusing the child. Where is it different than anybody else who takes care of the child?
The term fictive kin was created because many states were leaving out people who cared about a child, people who are important to a child. They required licensure.
Foster parents don't care about the child?
There were requirements of licensure for people who are not relatives in many other states. We were fortunate enough to already have a statute that allowed for contact.
To me, seems the easiest path to do. I would have jumped into those classes, whatever it took. DHS actually will fast track licensure for foster parents if they've already got a kid. They want this to happen. Wouldn't that have been the appropriate thing to do? Fast track licensure for foster parent, take over the neighbor, no longer be the babysitter, be the foster parent, keep waiting, because regardless, the DHS has got to go through family level first. So why didn't your clients take their time doing that instead of trying to jump to the head of the line?
Both, Your Honor, and the reason that they asked to intervene so quickly was because due to the child being in a non-concurrent plan foster home and having a parent who was not engaged in services, the department identified another stranger foster home who would be a concurrent plan to move the child to.
Actually haven't brought that up because I didn't think I wanted to go into the weeds this deep. That's crazy to think you have to have concurrent planning immediately. In my opinion, go check all my 8 years of juvenile orders. I don't think I ever ordered concurrent planning at the front end of a case. That's insane. Aren't you supposed to work towards reunification? Even if everybody thinks she walked out of the hospital, she's had 5 TPRs, you can see the writing on the wall. But until it's officially decided by the court, federal law requires reunification or placement with family. So this concurrent stuff doesn't sell me at all. Why is that a reason to jump?
The only reason that it was important here was that the department was going to move this child, which would be another move. In hindsight, we now know that there were other people who were interested or could become placement, but if we talk about the number of moves for a child.
They did become licensed foster parents in July, right? Is that right? It was a number of months later, but it was before the disposition hearing, right?
Foster parents prior to disposition.
Or to move the foster care from the existing foster parents to your clients?
Something, everyone's using the word move. There was not yet concurrent planning. In my opinion, that's a placement. They're trying to place while they're working on the goal. Isn't that a placement? They just need to place the child, and they don't know yet what the goal is. They have not yet stated concurrent goal. And so they are placing the child. That's different than moving. It may require a move to get the child there, but wasn't that a form of placement with the relative?
Placement with a relative, yes. Would have also required a move, would have also required a child to be in a community that they weren't familiar with, would have also required the child to not have contact with people that were important to that child.
Used to their community.
Toddlers, infants, they're used to the people who are around them. And so that would be the community that I would be referring to.
With that argument, when you're dealing with newborns and toddlers, it seems like your argument here is a presumption that whoever the child is placed with first wins, because those are the people that are caring for the child and who are building the relationship with the child, to the exclusion of what the statute says is the priority of other family members. So how can they build a positive relationship with the child if the child is placed with somebody else legally and they don't find out until it's too late, I guess, in your view, because once the positive relationship is established, then that supports the best interest finding that the child shouldn't be placed again. I find that a little bit troubling as a practical matter.
As we look at who are our relatives, many times there's an element of, and these are people that I know, that I have relationships with, say a grandparent who was visiting when I was in mom's care, or a cousin who came to the hospital and visited me when I was born. Those are all people who already also have connections to the child and the child's family. We're thinking of the people that the child knows. We think of relatives as people who we know. Within the 4th degree of consanguinity, we're talking aunts, uncles, cousins, great aunts. Those are all people that we believe we would already have a relationship with. And when we don't have that relationship and we have to create that relationship, maybe from states away, the question becomes whether that is in the child's best interest or whether supporting and fostering that relationship and maintaining their placement in the family in the circumstances that they have been accustomed to is better for them. And I think that's the question.
Private work in adoption world too, and my clients were always the pregnant girls, and they got to choose who they wanted. We had binders, we had a stable of people who really wanted to be parents. And my clients, many, many, many of them, they chose who they wanted. They picked who they thought would be the best person. That's Susie the lawyer. When I put on my robe years later and became a judge, we no longer have the luxury of just picking who we think is better. We could take a bus, there's a case in Ray Jessica, we could take a bus to some urban city and line up all kinds of kids who are living in poverty, maybe have abuse and all that situation, and I guarantee you I could find a better home for them. But when we are in the arena of neglect cases in Iowa, we don't have the luxury of picking who's better. No doubt in my mind are the babysitters good people and love that child, no doubt in my mind. But we have got to follow that statute. So how can, help me understand how you can treat it as if, I think you're trying to choose the better home. There's no doubt in my mind the statute says we have to look to relatives first. So why are you here today saying that was exhausted? Summarize, how was that exhausted? Because it has to be exhausted before you go to the next level.
Those relatives were found. They were located. They received documentation from the department as would be required. Certainly, it was much later than the code contemplates. However, at that point, the court began visits, frankly, over objection from some parties, and also began visits with the relatives in Illinois. When that became the department's chosen relative placement, it then took, correct, that became many, many months of requiring an ICPC with Illinois that took a very long time to be completed. And as the court looked at the relationship that she was building with those relatives, frankly, the record demonstrates that there were only very few in-person interactions by the time of the dispositional hearing. What does that relationship look like for this child? If we move this child, just as the guardian ad litem is required to determine what is the traumatic impact that could happen because of my recommendation. Well, the traumatic impact that the guardian ad litem found at that time was that we're taking away all of these people that she already knows. To place her in a placement that she really doesn't know, who has not come to visit her. And developmentally, does that set her back? Does she recede in the milestones that she's already achieved due to the stress that puts on the child? And so those are the reasons that the court needed to consider what was in her best interest, not just relatives who are appropriate being the only question that's asked.
Anybody else have questions? Thank you. Ms. Moran.
Thank you. The question of degree of a relationship on the evidence, the department disagreed with them at the time of intervention. There was some discussion about whether or not the department's position at the time was consistent with that. The department disagreed with allowing intervention on the status of fictive kin. So to the extent there's an error preservation question, the error was preserved from the state's view. But more importantly,
as I understand, as I remember, there was the county attorney who was not particularly gung-ho in opposition. Maybe that's why the AG ended up taking over the case. And the AG wasn't involved, you weren't involved at the time of the intervention. And then there was an HHS witness, but as I remember her testimony, it was more on the legal point. We don't consider a babysitter can become, or it can be fictive kin. It wasn't disputing the extent of the relationship. Am I wrong about that?
I think that's a fair interpretation of the testimony, if I recall correctly, but I think that goes to the point of, it's not about whether a relationship exists, it's about whether that relationship is such that they should be considered fictive kin so that it's just below relative. One of the other points that council mentioned was that the relatives here didn't have that relationship that existed prior to that we're saying needs to exist for fictive kin. The code section doesn't talk about it doesn't contemplate the nature of the emotional relationship between the child. It just talks about whether they're related within the 4th degree of consanguinity. So like the nature of the bond there doesn't come into play as it does for fictive kin.
When the department looks for family placement, sometimes they'll find someone from California who didn't even know the child existed, and then they build a relationship. So sometimes there's not even knowledge of family.
We even see that with parents at times.
Or can you direct me to the record, where was the court's findings that family placement was exhausted? And just because, I mean, Illinois and ICPC used to take 6 months. They only take 2 months now. I think that's awesome. But others might think that's way too long. But my point is, it takes time. You cannot let a child cross state lines that's in state custody without all that paperwork. So where was the finding by the court? Because usually when you say we're done looking at family, it's for negative reasons like the relationship's poor, that they're abusive or whatever it may be. Where is that?
That finding's not there, and that's part of the problem here.
The couple were doing all this babysitting for free. They were not being paid by the state at all. Is that correct?
Well,
They go to them and say, kind of maybe play straight with them and say, you should be compensated because you're essentially really you're kind of stand-in foster parents, or you're at least respite care, which is what they were. And this is really not a path to do an adoption, which I think is what they viewed it as. I mean, why didn't you play straight like that?
in the case of the time, I can't necessarily speak to the dynamics of it, but my understanding was that neither party was seeking or requesting that there was compensation for it, and it was more of a daycare type situation versus constant care, in addition to the 4 days of respite care that were shortly after the removal.
World where the department ever offers to pay something.
That's fair. I think in this case, the state again submits that in this case, there wasn't the requisite information in the record about whether or not these people were fictive kin at the time the finding was made. And there's the practical concerns that essentially every foster placement could become fictive kin and significantly cause delays in nearly every China case, which uniquely here we didn't have reunification going on, so it's not quite as central, but the concern for that across the state is significant and the impact would be pretty profound.
Me that a person could turn into fictive kin, you know, under a different set of circumstances, and that once a person truly has fictive kin status, that does make sense maybe to intervene because you're treating them like family and potential placement. So I think the whole thing on this intervention has to do with that tag of fictive kin.
Exactly. A lot of these issues kind of all turn on whether or not fictive kin finding is appropriate here. And
these problems, if we interpret the statute to require the fictive kin status to exist before DHS gets involved or removes a child.
state's position, that's the simplest reading of it that avoids a lot of the confusion and blurred lines. Because alternatively, how long does a China case have to go on before the relationship is such that it's fictive kin?
States that have chosen to define fictive kin in that way to make that limitation, and should we draw some significance from the fact that our legislature chose not to impose that?
Changes were made was the same year that Kentucky added that clause, and from my knowledge, there's no other states that address it that way, or the definitions are not akin enough to really be insightful for our purposes.
About saying that, because I remember the days when I was a very young prosecutor and involved in the China world. If you were an adoptive parent, you were not allowed to even say out loud, I want to adopt. I mean, if you were a foster parent, excuse me, foster parents could not say, I actually have a goal of adopting, because they found that to be contrary, that would work against reunification. And then they changed their mode to be, there's two different kinds of foster parents. The ones that just want to help out with the system, revolving door, come and go, and the ones who say, I actually want to adopt. So isn't that a little dangerous? Because we do want beautiful relationships to form. And if somebody is a babysitter to begin with, and then throughout the process, or a foster parent becomes really close and maybe the best option, I'm a little concerned about closing that door by reading into the fictive kin statute that you can't become fictive kin.
Practical implication that warrants this court's careful consideration.
Anyone else? Okay, you want to summarize? Yeah, you can summarize.
Here, the state simply asks that you interpret fictive kin as requiring a pre-existing relationship with the understanding, as the Chief Justice pointed out. But here, regardless of that statutory question, this family did not meet the definition at the time the finding was made, and with that, we would ask that this court vacate the Court of Appeals opinion. Thank you.
In the interest of LP is hereby submitted. We are going to take a brief recess while the parties get together for our next case, which is the Supreme Court's Attorney Disciplinary Board versus Kramer. Be seated. We are here now in the matter of the Iowa Supreme Court Attorney Disciplinary Board versus Valerie Kramer. Miss, are you planning on going first? Okay, go ahead. I had it on my notes here. I apologize. I was thinking that the board would go first, but you go first.
I think I'm going first.
You are.
Thank you. May it please the court, counsel. I'm here representing Valerie Kramer, who's here sitting with me earlier. Sole practitioner in Des Moines. She's been practicing here for over 20 years. Actually, the only person I know that went to the University of Chicago as a child. Graduated basically from there before she went to law school. Very, very smart. Very much involved with her clients. Represents people really from all walks of life. In probate matters, personal injury is not her thing, obviously. And she does wills, she does probate, she does that. She's not in a law firm. Basically, I'm here representing her before the court. I want to say before we start, I've been doing licensure cases for a while, quite a while. I've been before this court a few times. I have to say, as a member of the bar, I probably take the oath as seriously as any of us do. I know you all do. I have one prominently displayed in my office, which I read every day, because I think that's what governs who we are, how we practice law, why we're professionals, why we do what we do. And I truly believe Valerie Kramer has done the same and continues to do the same. What bothers me about this case is not just that she's my client and we're looking at what we thought was a very excessive sanction that was imposed by the grievance committee. It's how this process went forward. I totally support the fact that we have a self-regulated profession, that we have boards with volunteers on them, that we basically have a process by which we ensure due process, ensure professionalism. And something happened in this case. I've never had a 4-day ethics case, ever.
Matter. The billing. I am very concerned about the billing and what appears to be pretty clear examples of double billing, billing for work that was not done. Can we talk about some of those things? Would you like to respond to the board's allegations regarding that?
I will get to that if I might, Your Honor, but if I could, before we start. There's a couple things that I think are pretty critical here. One is the role of really Judge Raines, which I commented on in my brief. I don't know.
I really think you should get to the chief's question. Yeah.
The matter, and if there's time, we'll talk about those things. I want to know about the billing. That billing is gravely concerning to me, and I felt like a lot of, and I've read the transcript of the hearing, and yes, it was long, but when you have lots of allegations and lots of documents, that takes time. So my point is, a lot of the response to the billing issues seems to be more about the process. Let's assume, for argument's sake, I don't want to talk about the judge's situations. I want to talk about her billing. So how do you address the issues that were raised by ADB?
We addressed those in the hearing. Some of those, basically, we believe needed to be changed. We're not suggesting that we agree with all the allegations made. Is she a good bookkeeper? Obviously, she can use some improvement. No doubt about that.
Particular, half an hour to review an appearance. Do you think that's reasonable?
I can't say that it isn't. I don't know how long she took. Couldn't say.
Have you ever seen an appearance that says anything other than I, Susie Christensen, hereby submit my appearance for the respondent? Was that this case? Did you see the appearance they're talking about? It's one-liner.
In this case, there's some of the billing I can see where there were questions about it. I certainly don't see that true of all of it.
About a second brief that was identical to the first brief, other than changing the caption, and I believe there was a 4-hour charge. Help me understand that.
I didn't understand that one myself.
How about the waivers that were recycled and I don't doubt that first waiver was for whatever purpose it served, but then that same waiver was used over and over for different hearings. How do you explain that?
I don't think that's unique to Ms. Kramer. I think it's done sometimes, but on the other hand, would it be better that it was done differently each time?
Correct. I mean,
Yes.
I'd like to turn to Exhibit W. What is your client's response to the allegation that that was a phony email? From the client saying, essentially, go ahead and file the appeal.
I believe she followed what she was requested to do.
is an email allegedly from Selena Davis. It's a one-liner. Hi, with capital letters. Go ahead with the appeal. Thank you, exclamation point, Selena. That's it. And during trial, Selena testified under oath, I did not send that.
I can't explain it because I don't believe it was dummied up. I don't believe my client sent it. I can't explain it.
Would it be a fair inference, at least, that it was not an authentic email, or it was not sent by the client?
I don't believe so. I don't think there was any phony emails at all. I think the whole issue relating to Selena Davis, I think she was treated appropriately by Valerie Kramer, and I think, unfortunately, she became an issue in the case. But I think overall, I think she handled Selena Davis correctly.
Your brief where you say, Judge Raines had the institutional power to sit in the judgment on the very matter she set into motion. And I think this relates to you. Maybe you say it multiple times in the brief, that Judge Raines was sitting on the grievance commission or was a member of the grievance commission at the same time this matter was pending. Is that right? Is that, the board says that's incorrect, that immediately upon being appointed a judge, she resigned from the grievance commission.
About that. I think Katie Raines was in a situation where she was on the grievance commission. She was a probate referee. She filed complaints against Valerie, and actually she was a witness in a contested case before her. So in terms of, was there questions regarding what her situation was? Yes. Were they ever addressed? No. Was she part of a situation where she was involved in a deal and not as a neutral person? Actually, there was a case, I don't have it in front of me, but a Court of Appeals decision in which the Court of Appeals basically reversed Judge Raines, who had basically said that basically Valerie had submitted a will to probate that shouldn't be permitted.
Evidence that she was a member of the grievance commission at the time. I mean, I understand sometimes people can disagree about certain facts, but I don't think this is one of them. It's binary. Either she was a member or she wasn't a member. That should be pretty easy to establish.
Any evidence to suggest she was off the grievance commission at the time all this was pending?
Legal question. All right, if I really honestly don't know because I didn't do probate. If I file a application for my fees and the probate judge denies it, and the client says, well, that's perfectly good with me because then there's more money in the estate if the estate doesn't have to pay your fees. So I'd prefer you not appeal. Is the lawyer just out of luck?
Obviously, you appeal when the client requests you to.
I'm not asking that. I'm asking the legal matter. I mean, is the lawyer just out of luck? I mean, I just don't know.
Yes.
Took the Fifth Amendment in this proceeding. It's not a criminal case, and a number of other courts have held that an adverse inference can be drawn from a lawyer taking the Fifth Amendment in a licensing proceeding. Why should we not draw an adverse inference in this case?
Well, in this sense, she took the Fifth Amendment, and basically then there were questions raised by counsel for the prosecution. Why did you take it? And going into the detail of it. And if the Fifth Amendment means anything, I would think you don't inquire as to why somebody takes it.
You don't answer. A person could still ask a question, though, and she could take the Fifth again, correct?
I don't think you're in a licensing case before a panel of people that are basically going to decide the fate of Valerie Kramer. I don't seriously believe basically inquiring as to why she took the Fifth Amendment is something that they're entitled to ask.
I'm interested in talking about. One of them is her out-and-out refusal to withdraw, and it had to go all the way to hearing. I've never seen it go that far. Can you explain your client's behavior there?
That she's not withdrawing?
Yeah. When Supreme Court dismissed the appeal because she was not the attorney of record, the young gal Selena no longer wanted her services, and it had to go to hearing before she would get out of the case. Isn't that an ethical violation to not get out when you are either discharged by the court or fired by your client?
There was a real debate as to who was trying to get her out and why they were trying to get her out.
Involved. I think the board used the word firing, and then they withdrew that, and they said, whatever. Regardless, she was asked to not be the lawyer anymore. Someone else took her place. So however it happened, why didn't she just withdraw?
No, the answer to that. I don't know. Couldn't tell you. I wasn't there.
Concerned about the accusations against judges and court reporters. Other than her words, all she did was say they messed with the transcript. They changed it, or they told the court reporters to do that. And the ADB put on evidence by the two judges as well as the court reporters that that was not happening. Other than your client's words, what supports that outrageous statement?
In the sense that, in terms of the judges go, so if I could delve into that, we never really knew what they were going to say. I think maybe, no, they never, I'm sorry.
In testimony. No, I saw all your no, I'm talking. Ignore all the objections that were made. I mean, assume that the opinion testimony won't be considered. They were fact witnesses, and they testified, I never, ever told my court reporter, don't put that in the record or change the record, and the court reporters testified that they never changed the record. So that's the evidence. I'm ignoring anything that might be considered opinion. What evidence do you have for your client that it was monkeyed with?
I don't have any direct evidence. My client was in the hearings. She said when she got the transcripts, they weren't complete. That's what she said. That's what she still says. She says they weren't complete. When we basically had the judges testifying, and you say they were fact witnesses. I don't know. They were listed as experts. They were listed as experts. They never provided an interrogatory answer. We objected to everything they said. Now, now it's it.
Just because they weren't listed as experts, are you saying they are then forbidden from testifying as fact witnesses?
What I'm saying is they should have answered the interrogatory answers. We went to trial, and this is trial by this whole thing was trial by ambush, Chief.
For a moment. If I'm ignoring the expert stuff, okay, I'll give it to you. Nobody signed an affidavit or a statement regarding whatever, and all the testimony that might be considered opinion, I'm putting that aside. I am talking about fact stuff only. This is a yes/no question. If a person has not been designated as expert and may have given some expert testimony, but lots of other testimony about their personal observations, are you saying that that testimony is out about their firsthand observations?
About these two judges, yes, their testimony is out.
Observations are out. I'm not asking about opinion, first-hand observations.
At this point, their testimony is worth anything. They went out of their way not to tell us anything. We went in and we were blindsided. This is trial by ambush as far as I'm concerned. And then
Your testimony means nothing.
Positions, right?
I think I could have. And the reality is, I thought it was better to expedite it, since this thing went on for a long time, that they basically answer the interrogatory answers, which they didn't really answer them, and be under oath, that's fine. And then when we get to the hearing, we go hearing.
With that, the expert part of it seems a bit problematic, but you know, you can disregard all of that and you still have their facts that the grievance commission or we can still draw the conclusion as to what happened here, right? We don't really need their expert opinions, do we?
See, at the end of the day, basically the prosecution, what they basically say is, well, it's harmless error then. If we didn't answer those interrogatories, it's harmless error. I don't think it's harmless error when you're talking about a person losing their law license. We're not talking about maybe sanctioning them. We're talking about throwing them out of the practice altogether, which is exactly what they were trying to do.
Disregard all the expert opinions in analyzing the matter. Does that cure that particular issue?
Because if I thought it would, I would tell you that, but I don't think it cures it. I think the way this thing was prosecuted from day one to the end, and even today, is basically, if this is where we are with lawyer discipline cases in Iowa, God help us all. I always wanted to be a criminal lawyer in the worst way, and I guess I am, because if this is a process where you don't have protections in the process, this isn't the process I'm hoping that we would all be governed by. And I think you hope that we all administer.
That we find that the process here was appropriate, done according to the rules, that the board proved the violations as found by the grievance commission. Could you spend a minute discussing under those facts what you believe an appropriate sanction would be?
I think under those circumstances, I think basically there have been similar cases, which we cited in our brief, where there have been suspensions or there have been suggestions of people rehabilitation or have work on bookkeeping, for example, or other things. There's other things that can be done other than revoking a license.
Your brief mentions remorse. What is your client remorseful for?
No. But basically, it's the state's brief basically says they were critical, we weren't remorseful.
I'm asking because it's important to me in thinking about the analysis of what the proper outcome should be in a case. Your brief mentioned remorse, and so I'm just curious what your client is remorseful for.
This process like this, and to basically have people not believe her when she's spent her whole life attempting to do the right thing and representing people, and she's remorseful that she put everybody through this, and she's been through this, and she would hope this would never happen to anybody else.
I want to circle back to what you said. You've obviously represented a number of lawyers in these kinds of proceedings. As a court, we deal with a lot of these. I'm not sure what you find on this record that was so objectionable about this disciplinary proceeding and how it was in any way distinguishable from any other disciplinary proceeding we have. It seems like your biggest complaint is that people aren't believing your client's testimony, that these judges ordered transcripts to be altered, that she didn't fabricate an email from her client that the client said she didn't send. So what are the procedural deficiencies that you think occurred here that make this different than any other disciplinary proceeding?
Asking that question, Your Honor. I think never had a hearing that went 4 solid days. Never had a hearing where it was exhibit after exhibit after exhibit. Basically, we were responding to discovery even when we were basically going into hearings. There were deadlines provided basically everything would be produced right before the deadline. And basically, that's how the whole thing was contested. By the time we got done, they had a new prosecutor who was aiding the person who'd been with the prosecution the whole time, and we're adding people, adding witnesses, and basically, overall, it became way more complicated than I would have ever anticipated, and it became much more so, I think, based on really how it was handled, and I think why it was handled that way by the prosecution, I don't know. There were more people there, more exhibits there, longer hearing, more talk about it, more complaints, and basically, I don't understand that. I still don't understand it.
The board, your turn. Correct? Thank you.
May it please the court, counsel. We are here today because Valerie Kramer made egregious false accusations against members of the judiciary and because she took advantage of a vulnerable client, and her misconduct justifies revocation of her license. This court should revoke Ms. Kramer's license to practice law first and foremost because case law and protection of the public warrant this sanction. Second, the underlying proceedings were fair and impartial. And third, the board's conduct during those proceedings did not undermine them, nor did it violate any of Ms. Kramer's rights. I'd like to start first by talking about why revocation is the appropriate sanction here. Revocation is consistent with the purposes of discipline of the need for deterrence and the need to uphold the integrity of the justice system. And the two cases that best demonstrate this are Ronwin and Bjorklund. And what those two cases show together is that when an attorney engages in deception that is pervasive and severe and is especially targeted at undermining the validity of the justice system itself, the only way to protect the public is through revocation of that attorney's license. So I'd like to start first by talking about Ronwin. The attorney there in that case made very similar false accusations against district court and appellate judges, accusing them of committing fraud and engaging in conspiracy and baselessly alleging that they violated the Code of Judicial Conduct. And the court there noted that revocation was warranted when grossly disrespectful allegations are made, such as suggesting certain judges and justices were conspiring to conceal a crime, and when the allegations are totally unfounded and clearly a violation of the canons of professional ethics. And that is exactly what Ms. Kramer has done here. Ms. Kramer...
Disagree with you, Ms. Grove, that Ronwin is a pretty good precedent. I think Mr. Brown, maybe I'll ask him to distinguish it. But you would agree it's been a number of years since that, and in more recent cases, it seems like we've taken the position, maybe this is just the way society has changed, that judges need to really have a thick skin. And so we have like Attorney 792 and Neff, Neff use all kinds of foul names about judges that he disagreed with their rulings. And, how do we factor that in the fact that Ronwin's older and we have this more recent case law that says, judges, you need to have a thick skin?
We frankly haven't had a case like Ronwin since Ronwin. All of these other cases where there have been violations of 32.8.2D or 8.2A, the issues there were certainly that these attorneys were making allegations about judges, for instance, in Whittison, the allegation that the judge had brain cancer and that was affecting the judge's ability to engage in the judicial proceedings. But this is a far cry from those types of cases. We haven't had a case since Ronwin where an attorney has baselessly alleged that the entire system is rigged and that these judges are engaging in widespread conspiracy. And that, frankly, is a good thing. We haven't had a case like this since Ronwin, but I think that this is a good opportunity for the court to reinforce how serious that behavior is, because frankly, Ms. Kramer's statements strike to the very heart of public confidence. And that is the only currency that we have in the justice system. And so that's why revocation is really important here in this case, because we haven't had a case like it since Ronwin. And this is a
You know, the importance of public confidence in the system, shouldn't we, when a lawyer takes the Fifth Amendment before the Grievance Commission, allow an adverse inference to be drawn from that?
Our position on the adverse inference issue is that this perhaps isn't the right case to determine whether that should be permissible in our cases, because it's clear that the Grievance Commission didn't take an adverse inference. There was
Now, on de novo review, why shouldn't we apply an adverse inference?
The court certainly can. I think the issue is that the court doesn't need to, because there was so much information in the record about it. But the court, an adverse inference certainly, as you pointed out, is permissible in these cases, and other jurisdictions have done so, because the purpose of attorney discipline is protection of the public. And
cases, I mean, you have the U.S. Supreme Court in Spivak said you cannot revoke an attorney solely because they take the Fifth Amendment. That's sort of the baseline. And then when the cases support taking the adverse inference, it's usually in response to a specific question and then a specific inference about what the answer to that question would have been. Not just a general inference, the attorney is a bad guy because they took the Fifth. So maybe we should be careful and wait and do it in a more, address the issue in a more appropriate case.
I think that is how other jurisdictions have handled it, and I think that that is how Spivak should be interpreted, that an attorney can't be penalized just on the basis of invoking their Fifth Amendment right. But going back to the issue of revocation, I'd like to discuss Ms. Kramer's deception and her conduct mirroring that of Bjorklund. We've talked about Ronwin. I'd like to talk a little bit about Bjorklund, because the court there noted that his ethical infractions were numerous, varied, and serious. Moreover, he lied with reckless abandon, and the court stated, a lawyer who employs dishonesty as a routine component of his normal operating procedure clearly lacks the character required of members of the bar. And that is exactly what Ms. Kramer has done in these proceedings. Her other misrepresentations, other than the statements about the judges, as we discussed earlier, also showed this same deception as a routine component of her practice. Frankly, Ms. Kramer deceived at multiple stages throughout multiple cases. She made misrepresentations during the Waste case trial in 2022. She grossly inflated her billing statements in both the Crooks estate and in the Davis estate. As the chief noted, she also falsified the waivers in the Davis estate, recycling those waivers over and over. She fabricated evidence at the grievance hearing in this matter, both in her testimony and in 2 exhibits that she fabricated whole cloth before the commission. So because of this, the board has no confidence.
About the email specifically, other than the client's testimony that she didn't send the email, was there other evidence that would support fabrication? Was there metadata analysis, testimony, anything like that?
There was no testimony or evidence about the exhibit itself in terms of metadata or showing that there was no direct evidence about that, but the circumstances surrounding that email and surrounding the appeal itself demonstrate that this email didn't exist, because she filed the notice of appeal before the date of this email, and frankly, immediately following the date of this email, Selena hired another lawyer to get rid of the appeal because she didn't want it. And so there's really no evidence showing that at any point Ms. Davis wanted this appeal to continue, other than this email that Ms. Davis testified explicitly she didn't send.
The email, there was never an electronic copy with any digital analysis, is that right?
Digital analysis done of the email itself.
At least. I guess I have a concern about revocation in this sense. Ronwin was 96. Bjorklund, it seems to me there were a lot of other things going on in that case, including retention of funds and prior disciplinary history. I think our more recent cases take a more measured approach with respect to revocation, and maybe Ronwin is from a different era where the court more freely revoked as opposed to suspension with other. So address that specific issue for me, that we've kind of migrated away from revocation other than conversion cases.
So I think what's important to note here is, again, what we don't have is a perfectly analogous case to Ms. Kramer's misconduct where the court hasn't revoked. So what we can see is that in cases where the court hasn't revoked, what we're seeing is pieces of Ms. Kramer's misconduct. And her misconduct is worse than all of them. When you put it together, I think revocation still is the thing that makes sense here, because when you look at the cases that show pieces of her misconduct as being quite serious, for instance, Hagemeier getting a 2-year suspension, that was just the very similar billing situation to what Ms. Kramer has done, but that represents only a sliver of Ms. Kramer's misconduct.
Question. This issue about whether or not the judge was on the grievance commission at the time, can you just resolve this for me? It seems like it should be easily resolvable.
Executed an affidavit early on in the case when there was a motion to recuse based on that issue. She executed an affidavit in which she stated that she ceased her involvement on the grievance commission at the time that she took the bench. So it's very clear from our standpoint in the record that she was not on the grievance commission.
I understand it. Only attorneys can serve on the grievance commission.
They're not allowed to be on the grievance commission. And
She resign, or is she just automatically off?
procedurally how that worked for her, but she didn't have any involvement with the grievance commission during the pendency of any of these issues. She became aware of Ms. Kramer's misconduct at the time she took the bench, and then by that point, she was no longer involved in the grievance commission. So the suggestion that she was sitting on the adjudicative body is simply false. It's simply false. There is no support in that.
She would have been appointed to any grievance commission once she became a judge. Okay.
The grievance commission members, there was some suggestion that they needed to recuse because of some overlap with her service on the grievance commission, and those panel members also all stated with confidence that they had not served on a panel with with Judge Raines. So there was simply no overlap or issue with her prior service on the grievance commission.
Address Doe versus attorney Doe number 792, where we only did a private admonition when the lawyer sent a pretty heated email to the judge accusing the judge of unethical conduct.
Big distinguishing factor there is the fact that it was an email that wasn't widely disseminated, whereas Ms. Kramer's statements were in public filings, and she made those same statements throughout many public filings. And so there's a big distinction between an email that is sent between one or two parties and a court filing that is available to the general public.
Technical question here, but is a violation of Rule 8.2A always going to violate 8.4D?
I am unaware of any case where that hasn't been the case. Just generally speaking, when you think about what 8.2A is, I think that the court has really interpreted that as that is an attack on the administration of justice. And so I think I'm not aware of a situation where it would not be both rule violations.
8.2A issue, what other evidence do you point to for the 8.4D?
So the 8.2A was a big portion of that. Certainly, Ms. Kramer's failure to withdraw from the proceedings caused a lot of additional weight and burden on the system. So that is certainly an element of the 8.2 or 8.4D.
Set aside the opinions of the judges about ethics violation and limit our consideration to specific factual testimony they gave.
It doesn't affect the rule violations or this court's ability to find the rule violations, because there was so much evidence in the record of the rule violations that this court could simply, as it has done in cases past, excise any portions of the testimony that it deems to be offending. This court did that in Blessum. This court did that in McGrath. It did that in Akpan when it excised a witness's testimony entirely. So it certainly can do that on a de novo review.
show about her expressions of remorse, if any, at the grievance commission level.
Has at no point expressed any remorse. She waffled a little bit on her statements about Judge Porter, claiming that she was like, my memory of the record is that she stated at the hearing, oh, well, I guess I didn't really know why the transcript looked the way that it did. I just assumed, and maybe now I realize that wasn't quite right. But that is the extent, and she's never really expressed remorse about any of her misconduct. So the board's position is that she certainly shouldn't get a mitigating factor for any expression of remorse. In conclusion, Ms. Kramer has consistently and for her own self-preservation deceived those around her and undermined the validity of the justice system. And for these reasons, the board respectfully requests that this court revoke Ms. Kramer's license to practice law. Thank you.
May it please the court. Basically, I would ask, as you review this case, the transcript, and review the briefs, and consider the state of where we're at with licensure generally, that I think overall, this is not a situation where this lawyer should be revoked. When we look at, I think Ronman is way stronger than anything that Valerie ever did, way stronger. Now,
The details again. Not this case, but any other case. Would you agree with me that the fabrication of evidence is serious?
sure. Yes.
That is something we should consider?
I'm suggesting everything that was in this record you should consider, Judge.
That if there's a fabrication of evidence, and I know you will not concede that happened here, but if the court is persuaded there was a fabrication of evidence, that is serious. I also want to know your thoughts on the cases that were discussed. Conversion seems to be easy, but isn't the fabrication of evidence just as significant? Because if somebody creates evidence, that might end up in a judgment. It could be a form of getting money as well, or not having to give up as much. I want to know about that as well for purposes of revocation when it has to do with a situation where there's been deceit and the kind of billing that your client has been alleged to have conducted.
Well, in response to your earlier comment, you know we're not conceding that she fabricated evidence, and she didn't fabricate evidence.
Otherwise, what would you recommend for discipline?
If there's going to be any discipline on Valerie, I think it would be some form of suspension, not revocation. The idea of removing her from the practice altogether is not warranted, and I've never believed that. In fact, I was surprised at the hearing that basically at the end of the hearing, counsel stands up, learned counsel, and we had a professional relationship, so I have no issue with them personally, that that's what they wanted, was revocation. And I just think that's too severe, too extreme. I think she's done a lot of good things in her practice, and I think she should continue to be able to represent clients.
Another factor, or let's just say this is the factor. If the court is persuaded that she made those comments regarding Judge Porter, Judge Raines, and the court reporters, and that they were monkeying around with the transcripts, which to me is not just this case. A lot of complaints will be about my case, my case, my case. But when you accuse a judge of monkeying with transcripts, that puts their whole career, every case before and after, on the line for scrutiny. So if we were to find that she did indeed baselessly make those claims against two judges and two court reporters, what do you recommend for the discipline?
Basically, when she made those allegations, she's the one that was in the hearings, and she yeah,
And that we're not persuaded.
transcripts, and she said that was not what happened.
Recommending for suspension if we assume they were baseless statements and they were not true. Assume we're going to do the credibility on de novo and we're going to believe Judge Porter, Judge Raines, both court reporters. And I believe also The lawyer, the opposing counsel in the waste case also testified that he reviewed the transcript and believed it was an accurate representation of what happened. So if the court is persuaded that that is absolutely not true and it was baseless, what do you recommend the suspension should be?
Well, years ago, there was a case, I still remember it, which I was clerking at this court at that time.
Okay, but what do you recommend would be the discipline for something like that?
If I could, please. And that is where basically somebody alleged in a petition for rehearing that basically the court overlooked or misled or didn't pay attention to authority that was controlling. And after that, there was discipline imposed, but they didn't revoke him.
And I appreciate your zealously representing your client, but it's kind of a question that deserves an answer. What do you recommend would be her discipline if we are not persuaded there was any evidence to support her allegations of messing with the transcript by judges and court reporters? What do you recommend is an appropriate sanction?
Some form of suspension, that's it.
Not revocation. Thank you.
I think that's extreme, and too extreme. And there's a reason, as Justice Manson pointed out, we haven't had a case like this since Ronwin, not really. And the other cases have come down, and I think Justice McDonald, you've measured, basically takes a more measured approach, that there's an opportunity to proceed, and basically there's been suspensions or conditions basically about being a practicing lawyer, but not revoking them.
You may summarize your request.
We would respectfully request that this decision by the grievance panel be reversed, that any sanction that's going to be imposed be appropriate, and that she not be revoked. Because what I am concerned about is, at that point, her career would be over, and there's no path to come back. And she's put a lot into it, a lot of things testified, people testified on her behalf as to what she's done for them, and I think she's a credit to the profession, and she should be permitted to continue to practice. Thank you.
The case of Attorney Disciplinary Board versus Kramer is hereby submitted, and the court will recess until afternoon.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.
Dave, what about the recording that was never turned over?
Yes.